Welcome to our YouTube video series on Termination Severance Pay. My name is Christopher Neufeld, the Neufeld Legal. And in this particular video, we're going to be discussing individuals who work under the classification of a contractor or independent contractor and whether or not they're afforded termination and severance pay when their engagement with a particular company comes to an end. And the mere fact that you are classified and you're treated as a contractor, or more specifically an independent contractor, and the agreement that you have with the company states that you are an independent contractor, is not necessarily the last word. It reflects what the company wants to do, and it might well reflect some interest on your part. But oftentimes, individuals such as yourself are looking for employment, and the only way they can be employed and the only way that they can be engaged is if they follow the rules set forth by the company that's engaging them and agree to be engaged as a contractor or independent contractor. However, the law is a law, and the law is different from what the contract says, and it takes precedence over what a contract may say. In the fact that even though the piece of paper and even though the pay arrangements are that of a contractor or that of an independent contractor, the law might in fact classify that individual as an employee. So what becomes critical to this process is understanding the distinction between an employee and a contractor, more specifically that of an independent contractor, which most companies are attempting when they try to misclassify and reclassify individuals in their employ as independent contractors. So let's go through those key categories and make some direction on whether or not you as an individual are in fact an employee or an independent contractor, at least in the eyes of the law. And then we could talk about what the aspects and what the impact is on termination and severance pay. So first off, does the company control the individual's activities? Who is making decisions? Is it the company or is it the individual? Does the individual only have limited direction and they get to control how they proceed? Or is it the company that pretty much dictates everything? If you have the degree of independence, the ability, the freedom to do your work without constant supervision, then you're possibly an independent contractor. When there's strict parameters, there's heavy supervision, and if the company is dictating what needs to be done, how it's to be done, the times during which the operations are to occur, and manifesting supervision over the activities of the individual, that is not properly an independent contractor relationship. It is more that of an employee relationship. Next, we look at the individual's use of tools and equipment, whether they are owned by the individual and simply brought into the site, or if they are owned by the company and the company dictates what tools, equipment are used and really gives no independence as to use and selection of tools to get the job done. Because when you are coming into an operation, you're required to bring your own set of tools, especially as an operator. You're going to find yourself being treated as an independent contractor. But if you're simply showing up and relying upon the tools and equipment of the ownership, that is that of an employee. Next, you need to look at whether or not you're capable of hiring helpers. If it's you alone and always you alone, that is something different from that of an independent contractor who's able to bring in additional resources. And resources includes people. Because when you have a task to be done, if you believe as an independent contractor it's more efficient, provided that people are cleared, to use other individuals along with yourself to get the task done at the set rate that you're provided with, that reflects an independent contractor arrangement. If there's no intention to allow anyone else and simply yourself working exclusively on the behalf of that particular company, you're talking again an employment relationship as opposed to an independent contractor relationship. Next, we look at whether there is any degree of financial risk to an individual. If you're making an hourly rate or a set rate and there's no concern about not making that money, there really isn't financial risk. Where financial risk comes into play is a situation where you're told you have to do this for this amount of money, irrespective of how much time you put in and how much resources you put in. So you could be doing the job, mess up the job, have to correct the job, and not be in the black, but be in the red on a financial perspective from doing the job improperly. There is a degree of financial risk involved. And that's something that independent contractors face. But on the flip side, you also have the opportunity for profit from the work beyond the fixed hourly rate, beyond the daily rate, beyond the set rate. Because if you can do it efficiently, get it done correctly, your profit margin can swing upwards and downwards once again. And this is something that's endemic in an independent contractor relationship, but not being present in an employment relationship. And finally, one of the other major factors that you see is the aspect of whether or not there is exclusivity with respect to the company. Is the company not only requiring to work only for themselves, but are the timelines such that there's really no capacity to work for anybody else? If you're working 40, 50, 60 hours a week for that company, if that company's flying you in and flying you back, and you're spending regular periods up there, that's not an independent contractor relationship, really, unless other factors suggest otherwise. If you're fully committed and fully expected to be only working for that company for a requisite period of time that reflects full-time work, you're really an employee. They can present it differently, but you're still only an employee. You're not really an independent contractor. They're using the facade of an independent contractor to control the financial spectrum. So when it comes to termination severance pay, and now we come into it, they have a greater ability to just say, we're done with you, have a nice day. We're not paying you weeks and months of termination severance pay that we would otherwise pay you if you were an employee. But you might well be an employee. Simply because you have paperwork that says independent contractor, even though by law you're an employee, the question becomes what you really are and how you're going to challenge it. So then you look at cases that have come before the courts and they were favorable to individuals who challenge the proposition that even though their employer, the company that was paying them, engaging them, classified them as an independent contractor, they were in fact employees, and as employees they were entitled to termination severance pay. We look at such cases as Keenan versus Canac Kitchens. We look at Phillips versus Jakin Engineering Construction Ltd. And we look at Weber versus Coco Homes Inc. Each of these cases, very specific, very unique, oftentimes going to be unique from your own situation, but nevertheless showing important concepts and legal principles. And so the fact that you might well be an employee, and even though your employer or the company that's paying you would like you to believe that you're an independent contractor, is structuring your business arrangement as an independent contractor, that does not necessarily represent the be-all and end-all. Because if you're properly an employee, you may well be entitled to the termination of severance pay arrangements that are entitled and are founded in law and even founded in statute and are provided to employees. Naturally, the challenge is you're coming against a large company, oftentimes, who are interested in protecting their own interests. And not only dealing with yourself, but dealing with all the other independent contractors that they claim to be dealing with, who, if they are misjudging the fact, are now all employees as well. And for this very reason, they have a very strong incentive not only to challenge yourself, but to challenge yourself on the basis of what it does from an impact standpoint with respect to all their other engagements of other personnel, both current, former, and going forward. Because the last thing they want to do is they want to increase their financial costs. And what you're doing by saying, well, you might very well be an employee, not an independent contractor, is you're messing up their financials and you're increasing their costs that they have to pay to the individuals who are working for them, especially when it comes to termination time. Because now those individuals are going to be classified as employees, becoming entitled to termination severance pay, and in addition to that, may very well be obligated to be receiving other payments during the course of their employment. It's something that these companies don't want to do, and as such, they're going to challenge it, and they can put significant money and legal resources to fighting it, at least initially. But if it's your entitlement, something you should properly consider, should talk to legal counsel, understand what the challenges are, the drawbacks in doing this, but also what might be available to yourself. And now, again, is the risk worth the reward? Something that is not considered previously by your employer, but in a different context, what are you potentially going to cost yourself? And is there any real fallback? Because there are situations where this is definitive, clear-cut, and the lawyers can make a very strong and substantiated case. And there can be substantial returns for yourself. The critical thing is, where are you from a positional standpoint to move forward on it? And that is something that you should be talking with a lawyer before you get too heavily engrossed in this and take this too much and possibly out of context and get too excited about it. But at the same time, there is potential there. It's just a matter of addressing it and having the right fact pattern and situation and having it apply correctly to the law and be aggressively prosecuted, preferably by a knowledgeable legal counsel. And that's how you want to deal with these situations where you might be claimed as an independent contractor or contractor, but you're rightfully deserving of termination severance pay as an employee. Thank you.